On a still morning in Angola, Louisiana's maximum security state prison, a transport van rolls through the gates. Inside are men whose names are etched into the state's most serious cases. Death row inmates bound for facilities they will never speak of again in public records. There are no sirens, no crowds, no cameras. Just uniformed guards, locked doors, and a quiet that seems almost intentional. For years, Louisiana corrections officials have moved death row prisoners in silence. Different prisons, different wings, often at unpredictable hours. Some of these moves are recorded in court filings and public schedules, but many details remain buried in bureaucracy. Why are these transfers seldom announced? What does secrecy mean for the men inside, for their families, and for the transparency of the justice system itself? What was happening behind the walls when those vans pulled out? And why did the state choose quiet over openness? This documentary will explore the real history and practice of death row transfers in Louisiana. We will examine why these moves occur, how the Department of Public Safety and Corrections manages a system that is often invisible to the public, and the human and systemic consequences of relocating condemned inmates. Every event and policy described here is based on verified records, official reports, legal documents, and interviews with experts, lawyers, and people directly involved in the correctional system. Our goal is not to sensationalize, but to educate, to shed light on a corner of the criminal justice system that operates behind closed gates and limited oversight. This documentary is for educational and informational purposes only. All content is based on factual, research-driven information from public records, official documents, court filings, and reporting by reputable media and human rights organizations. No information is intentionally fabricated or exaggerated. Before we proceed, please like, share, comment, and subscribe to support the channel. In the late 20th century, Louisiana's death row looked very different than it does today. For decades, inmates sentenced to death were housed in various facilities across the state, depending on capacity, security classification, and medical needs. By the early 2000s, concerns began to surface about overcrowding, inconsistent conditions, and difficulty providing adequate supervision. At the same time, the state faced legal pressure to ensure that incarcerated people receive constitutionally required access to legal counsel, medical care, and safe living conditions, even when their sentences were the most severe. Records from the Louisiana Department of Corrections show that between 2005 and 2015, the state instituted a series of internal policies to centralize death row populations at specific facilities. These policies were driven in part by court rulings that found certain housing arrangements deficient, and by corrections leadership who argued that centralization would improve management. But the way these moves were carried out raised questions. Rather than notifying families, attorneys, and the public well in advance, many transfers were scheduled quietly, communicated only to those with direct clearance. News reports from the time noted confusion among families trying to keep contact with their loved ones after a sudden relocation. Advocates expressed concern that secrecy could violate inmates' rights and hinder oversight. In one public case filed in federal court, a death row inmate argued that a sudden transfer had disrupted his ability to communicate with counsel and gather evidence for ongoing appeals. The filing did not claim deliberate misconduct, but it highlighted how unexpected moves could affect due process, especially when notice is limited. As the van gates closed that morning in Angola, guards followed routine and regulation. Yet for the inmate inside, the destination was unclear and the reasons for the timing even more so. Across Louisiana, similar moves had become a pattern, one that drew scrutiny from defense attorneys, civil liberties groups, and journalists alike. What remains less clear to the public is how often these transfers occur today and what criteria officials use when deciding who moves where and when. Louisiana's death row hasn't always looked the same. Its management has evolved in response to legal challenges, budget pressures, and shifting leadership. But for the families and advocates watching a prison door close, questions often outweigh answers. Psychological and system analysis. To understand the impact of these silent moves, it helps to examine both inmate psychology and institutional behavior. For inmates facing a death sentence, stability and routine are among the few predictable elements in an otherwise controlled environment. Sudden transfers can disrupt sleep cycles, access to spiritual or legal counsel, and emotional bonds maintained through visitation. Research in correctional psychology suggests that uncertainty and loss of control can increase stress, anxiety, and feelings of isolation, effects that are intensified when the future already feels constrained by a death sentence. From an institutional perspective, corrections administrators must balance multiple priorities: security, legal compliance, staffing limitations, and resource allocation. Facilities that house death row inmates require specialized training for staff, appropriate medical and mental health services, and infrastructure to safely manage individuals with serious criminal convictions. At times, a facility may reach capacity or experience staffing shortages that trigger transfers. Decisions to limit public notice likely stem from concerns about security and operational efficiency. Announcing movements of high-security inmates could, administrators argue, create safety risks or logistical complications. Yet this very opacity raises concerns about transparency and accountability. Critics point out that without clear public reporting, it becomes difficult to evaluate whether transfers serve legitimate administrative needs or unintentionally harm inmates' rights and well-being. The Louisiana Public Records Law provides avenues for citizens and journalists to request information, but bureaucratic delays and redactions often slow access to transfer logs and policy details. As death row locations shift and internal memos circulate within corrections departments, the outside world often remains unaware of when and why moves happen. And for those inside, each silent transfer carries psychological weight, a reminder of the constant flux that defines life on death row. For most people outside Louisiana, the name Angola is simply a point on the map. For people inside the criminal justice system, it represents something much larger: the Louisiana State Penitentiary, one of the largest maximum security prisons in the United States. For decades, this sprawling former plantation became the central hub for the state's death row. By the 2010s, Angola housed nearly all of Louisiana's death sentence prisoners. Wide fields, long ranges of cell blocks, and strict security procedures defined daily life. Angola had the infrastructure the state said it needed: isolation units, medical facilities, and trained staff capable of managing the highest-risk population. But centralization also meant that each decision made at Angola shaped the experience of nearly every person on Louisiana's death row. When transfers were ordered, whether temporary or permanent, they often began and ended here. Internal policy changes, lawsuits regarding heat conditions, mental health treatment, and access to legal resources slowly pushed the system to adapt. Some court rulings required Louisiana to review housing policies for inmates with serious medical or psychiatric conditions. Others focused on the physical environment, including allegations that excessive heat in cell blocks endangered health. Each legal development added new pressure to a system already operating at maximum security. Behind administrative doors, officials discussed options: move certain inmates to medical units, shift others to different wings, or in rare cases transfer individuals to entirely different facilities. To the public, very little of this was obvious. There are no press conferences for individual transfers, no published schedules for vans leaving at dawn. Families often learned of moves only when a letter was returned, a phone call failed, or visitation rules suddenly changed. Advocates described long drives to Angola, only to discover that the person they planned to visit had been relocated without prior notice. From the corrections perspective, officials stated that safety and order required flexibility. Moving high-security inmates involved complex planning, staffing, routes, security classifications, and the fewer people aware of the plans, the lower the risk of disruption. Yet the absence of notice created another kind of risk: the erosion of trust between the state and those directly affected by it. One transfer in particular, documented in public filings, involved moving a seriously ill death sentence prisoner to another facility capable of specialized care. For administrators, this was an operational necessity. For the inmate's family, it was a sudden disappearance, followed by weeks of questions and limited communication. Each move carried layers of meaning. For the state, it was logistics. For attorneys, it was case access and legal rights. For the inmate, it was another unknown corridor, another door closing, another reminder that even location was beyond their control. As Angola continued to serve as the central node in this system, pressure from courts, advocates, and budget constraints steadily increased. The question facing Louisiana corrections officials was no longer whether transfer should happen, but how open or closed the process should be. And then, a proposal emerged that would challenge the entire structure of where death row belonged in the state at all. What happened when Louisiana considered moving death row out of Angola? And what forces pushed that debate forward? As legal challenges mounted, Angola's role as the permanent home of Louisiana's death row began to be questioned in public forums rather than only in internal memos. Lawmakers, civil rights attorneys, and corrections officials found themselves drawn into the same conversation. Should death row remain at Angola, or should it be moved? The discussion did not come from a single event, but from a steady accumulation of concerns. Heat litigation, questions about access to medical care, disability rights cases, and changing national standards on confinement all converged. Reports from advocacy groups and statements made in court raised concerns about long-term isolation, aging populations, and the costs of maintaining specialized housing inside an already massive facility. Within this environment, proposals surfaced to relocate Louisiana's death sentence prisoners to other state facilities better equipped for medical or mental health needs, or to units designed with newer infrastructure. Public meetings, committee hearings, and legal filings reflected a rare moment of openness about a process that was usually silent, the moving of people on death row. Yet even as the policy debate became public, the transfers themselves largely did not. When selected inmates were moved for medical treatment, court appearances, or reclassification, the pattern continued: quiet schedules, early morning departures, and limited advance notice. To many families, the debate offered hope for clearer communication and better conditions. To corrections administrators, it represented logistical and financial challenges, redesigning units, retraining staff, and ensuring security during and after any relocation. There was another layer as well. Angola had become symbolically tied to Louisiana's death penalty system. Moving death row meant more than transferring individuals. It meant altering decades of institutional identity. As the debate progressed, one question dominated the conversation among officials and observers alike. If the state decided to move death row, how would it do so? Openly through public timelines, or through the same silent transports that had defined past transfers? The answer, when it began to form, revealed just how closely secrecy and security had become linked within the system. Plans took shape. Buildings were evaluated, transport lists were drafted, and then, as the first coordinated relocations were discussed, another issue rose to the surface: what happens inside the prison system in the days before a major transfer? Inside a prison, change is rarely invisible to the people who live there. Even when official announcements are limited, small signals appear: increased movement of staff, brief meetings, property inventories, sudden schedule adjustments. On death row, where routine is precise and controlled, those small changes take on greater meaning. Former staff and legal observers have described the pre-transfer period as a time of controlled uncertainty. Inmates may not be told exactly when or where they will be moved until shortly before it happens. Belongings are cataloged. Legal papers are packed. Contact with families may be disrupted temporarily, not as punishment, but as a byproduct of movement between facilities. This uncertainty serves practical purposes in the eyes of corrections leadership. It reduces the risk of planned disruptions, limits the spread of rumors, and helps maintain order during a complex operation. Moving any high-security prisoner requires coordination between transportation units, receiving facilities, and central administration. But the human experience inside those logistics is quieter and heavier. Being transferred on death row does not change the sentence, the legal status, or the past. Yet it changes surroundings, routines, and access to familiar supports. A lawyer accustomed to visiting at one facility must adjust to another. A family member who drives hours to scheduled visits must learn a new route and new rules. For some inmates, moves can also mean different mental health care, new cell environments, or alter recreation schedules. Psychologists who study incarceration note that anticipation without information can heighten stress responses. For a person already living under a death sentence, sudden change can intensify feelings of uncertainty about the future. None of this excuses crimes or erases consequences, but it helps explain the psychological impact of system design choices. Corrections officials remain focused on their own set of pressures: court orders, staffing, safety, and policy compliance. For them, transfers are tools of management, not messages. Their decisions are bounded by law, budgets, and risk assessments that rarely reach the public eye. In the final hours before transport, paperwork replaces debate. Names are checked, routes are confirmed, doors open and close in sequence. And once again, the vans roll out quietly. Where they're going is listed in official records. How and why those particular individuals were chosen at that particular time is often harder for outsiders to see. The question that persists beyond the gates is simple, but unresolved. Can a system balance safety and secrecy without losing transparency and public trust? Outside the prison walls, the record of a death row transfer often lives on paper rather than in public announcements. Movement orders, classification reviews, and transportation logs exist, but accessing them can be slow and difficult. Journalists and researchers have used public records requests to piece together timelines, sometimes waiting months to receive heavily redacted documents. The paper trail tells its own story. Transfer decisions are typically grounded in policy language: security level, housing availability, medical need, mental health status, disciplinary history, or court-ordered appearances. Each phrase is administrative, but each represents a real person being moved from one locked environment to another. Louisiana's corrections system operates under regulations designed to prioritize safety and legal compliance. Yet those regulations often allow broad discretion. Administrators may act quickly when conditions change: a facility renovation, a staffing shortage, a storm threat, or a court ruling about conditions of confinement. In these moments, speed outweighs transparency, and moves are arranged with minimal external notice. Advocacy groups argue that the public has a legitimate interest in knowing where death sentence prisoners are housed, not to sensationalize cases, but to ensure constitutional protections. They emphasize that secrecy, even when motivated by safety, can limit oversight into living conditions and access to counsel. Corrections leaders respond by pointing to security risk. Publishing detailed movement plans could create vulnerabilities during transport, a stage already considered one of the most sensitive in prison operations. Even after the fact, officials are often cautious about releasing specifics, fearing that patterns could be analyzed and exploited. The result is a tension between two values: transparency in a democracy and security in a prison system. In hearings and courtrooms, the issue repeats in careful language. Attorneys request records. Officials cite risk. Judges balance both sides. And behind each legal argument is the quiet fact that men on death row are being moved between facilities with very little public awareness. This is not unique to Louisiana. Across the United States, high-security transfers are often conducted outside public view. But Louisiana's long history with Angola and the symbolic weight of its death row make these questions especially sharp. As more records became available over time, a clearer picture began to form. Transfers were not random or chaotic. They were systematic, deliberate, and often tied to long-term institutional strategy. Still, one question remained difficult to answer. How do these silent moves affect the people most directly involved? The answer lies not only in policy documents, but in human behavior inside intensely controlled environments. For most people, Moving means boxes, addresses, and phone calls. For someone on death row, moving means restraint procedures, formal escort, and a new cell they did not choose. The experience of transition in a high-security prison is structured and regulated. Yet the psychological effects are deeply personal. Correctional psychologists describe 3 common reactions to unexpected transfers on death row. The first is heightened vigilance, a natural response in a new environment, especially where rules and social dynamics are unfamiliar. The second is disruption of routine. Even small changes, such as a different schedule for showers or legal visits, can feel large in a setting where daily structure is everything. The third is uncertainty about the future, intensified when reasons for transfer are not fully explained. None of these reactions are unique to guilty or innocent individuals. They're human responses to sudden change in confined spaces. Transfers also affect staff. Officers must adapt to new inmates with different histories and needs. Training is revisited. Procedures are reinforced. The possibility of miscommunication rises during any transition, which is why administrators plan transfers in detail, even if those plans remain unseen by the public. Families experience yet another layer of impact. Travel distances can change by hours. Visitation rules may differ from one facility to another. Phone systems are not always identical. For some families already facing financial strain, a transfer can mean fewer visits, not by choice, but by geography. The legal system feels the effect as well. Attorneys sometimes adjust meeting schedules, refile visitation requests, or navigate new prison procedures just to continue communication with their clients. For people on death row, where appeals and post-conviction litigation are complex, access to counsel is not simply a convenience. It is a constitutional right. Despite these challenges, transfers continue because the correctional system views them as necessary tools. Facilities age, populations shift, healthcare demands increase, court orders require change. In that reality, movement becomes part of the landscape of incarceration. Behind every administrative justification, however, is a person adjusting to new walls. As Louisiana continued the practice of transferring death-sentence prisoners, one theme became impossible to ignore. The system itself was changing. Legal standards evolved. Public expectations about transparency shifted. Technology made it easier to ask questions and harder for institutions to remain completely silent. Yet the transports still left at dawn. The announcements were still limited, and vans continued to disappear down long roads lined with fields and fences. The next turning point would not come from inside the vans, but from outside pressure, courtrooms, legislatures, and public debate asking whether secrecy in death row transfers could coexist with modern demands for accountability. As the years moved forward, the discussion around Louisiana's death row transfers increasingly shifted into courtrooms. Lawyers did not focus on the drama of transport itself, but on what those movements meant for rights guaranteed under the Constitution. Petitions raised practical questions. Did sudden transfers interfere with attorney access? Were people with serious medical or mental health needs being moved to facilities that could properly care for them? Were conditions during and after transfer consistent with court rulings on humane confinement? These were not abstract debates. They were anchored in real cases and sworn testimony. Judges requested documents. Agencies provided policies, logs, and affidavits. Experts were called to explain how stress, isolation, and frequent moves can affect mental functioning, particularly among people already facing extreme sentences. Corrections officials described security risks and operational limits that shaped every decision. Each side revealed part of the same system, seen from different vantage points. Gradually, a record built up, filings, orders, transcripts, showing that transfers were not random or secretive for the sake of secrecy. They were embedded in a large network of institutional pressures, costs, staffing, facility design, court oversight, and legislative funding. Yet public questions continued. Families asked why they were not notified sooner. Advocates asked whether transparency could be improved without compromising safety. Journalists filed records requests and compiled spreadsheets tracking where death sentence prisoners were housed over time. The result was a clearer picture of a process that had long operated quietly. Meanwhile, inside prisons, daily life went on. Legal arguments outside did not change the experience inside overnight. Schedules, counts, inspections, and security checks continued without interruption. For individuals on death row, the courtroom debates often came filtered through attorneys' visits and carefully worded letters. The central issue remained unsettled. How much information about transfers should be public, and how much should remain restricted for security reasons? As that debate continued, another reality asserted itself. Louisiana's death row population was aging. Medical complications increased. Healthcare requirements grew more complex. And with that shift came practical consequences for how and why transfers occurred. Over time, many people on Louisiana's death row grew older while their cases moved through lengthy appeals. With age came health conditions common to any aging population: heart disease, respiratory problems, mobility issues, and mental health diagnoses that required treatment. This change altered the transfer landscape. Prisons that were originally designed with security as the primary priority now faced expanding medical demands. Some older units lacked easy access to specialized clinics or equipment. In certain cases, death-sentenced inmates were moved temporarily or permanently to facilities with more advanced medical capabilities. The reasoning was administrative. Access to care required movement. Each such transfer remained highly controlled, planned in detail, and largely unannounced beyond those who needed to know. But the motivation had shifted. It was no longer only about housing space or disciplinary management. It was increasingly about health, vulnerability, and legal obligations to provide adequate medical treatment. With medical transfers came another layer of psychological impact. For some inmates, movement tied to health issues reinforced a sense of physical decline. For others, it brought slightly improved access to treatment or evaluations. In all cases, it underscored a complex truth. Even under a death sentence, the state retains responsibility for the well-being of those in its custody. Corrections officials had to balance multiple logistical strands at once: maintaining security classifications, coordinating hospital access, arranging specialized transport, and staying within budget constraints. Transfers became part of the infrastructure of prison healthcare. Outside the prisons, advocates and families continued to ask why so much of this process unfolded quietly. Inside, people adjusted to new medical units, unfamiliar corridors, and revised routines. The combination of aging populations, legal oversight, and institutional limits created a new phase in Louisiana's death row history, one where transfers were both more necessary and more scrutinized. That scrutiny would soon intensify when weather emergencies and natural disasters put unexpected stress on the entire prison system. Louisiana is no stranger to hurricanes, floods, and severe storms. When natural disasters threaten large regions, prisons face a unique challenge. Thousands of people cannot simply evacuate themselves. Movement must be organized, secure, and fast. During major weather events, transfers, including those involving death-sentenced inmates, sometimes occurred as part of broader emergency plans. Facilities in danger zones prepared contingency lists. Buses and vans were staged. Alternate housing locations were identified in advance. Again, much of this planning took place out of public view, not because it was unrecorded, but because security required limited disclosure. In crisis situations, the priority becomes safety and continuity of custody. Announcing detailed movements in advance could complicate evacuation logistics or create risks along transport routes. For that reason, officials typically kept schedules restricted to operational personnel. For inmates, emergency transfers added another form of uncertainty. Moves that were already stressful became layered with concern about the disaster itself. Communication with families could be interrupted by power outages, flooded roads, or damaged infrastructure. For families on the outside, the effect was deeply practical rather than dramatic. Busy phone lines, unanswered calls, and delayed confirmation of a loved one's location. After storms passed, some inmates returned to original facilities. Others remained in new placements due to damage, reclassification, or long-term adjustments. These emergency transfers reinforced a central reality of the system. Movement is part of custody, driven by factors ranging from court orders to weather. And every transfer, planned or sudden, leaves a record, even if that record is not immediately visible to the public. As Louisiana's prison system adapted to crises, another conversation continued in the background, whether the secrecy surrounding these moves was a permanent necessity or a practice that could gradually evolve. The answer was slow, shaped by policy reviews and changing expectations about openness in government. Over time, public institutions across the United States faced growing expectations for openness. Louisiana's prison system was no exception. Legislators asked more questions. Public records requests increased. Academic researchers and investigative journalists continued examining where death sentence prisoners were housed and how often they were moved. Small but meaningful shifts followed. Policy summaries became more available. Court orders occasionally required clearer documentation of transfers connected to medical care or legal access. Advocacy organizations compiled and shared information that, in earlier decades, would have been nearly impossible to assemble. The core tension, however, remained. Corrections officials emphasized security. They argued that operational details about specific movements could introduce risk. At the same time, families and attorneys emphasized communication. They argued that sudden transfers without notice increased stress and complicated already difficult legal processes. Neither side fully controlled the system. Instead, policy evolved gradually, case by case, hearing by hearing. Within Angola and other Louisiana facilities, the practical reality continued. Transfers were part of daily administrative life. Some were temporary, some permanent, some tied to health, others to court appearances or classification changes. The silent moves were not part of a single hidden program. They were the cumulative result of security doctrine, institutional culture, and long-standing prison practice, conducted quietly by design, documented in internal records, and often felt most directly by the families trying to keep track. The story of Louisiana's death row transfers is therefore not a single event, but a system built over decades. It is a story of vans leaving at dawn, of policies written in careful language, of legal cases that rarely make headlines, but slowly reshape how institutions work. It is also a story of how secrecy and transparency can coexist in permanent tension inside the modern criminal justice system. And it leads to one final question: what does the future of this system look like? Today, discussions about death row in Louisiana continue within legislatures, courts, universities, and public forums. Broader national debates about the death penalty itself intersect with practical issues such as prison design, aging populations, costs, and constitutional obligations. Any future change, whether in housing location, policy transparency, or the administration of death sentences, will influence how and why transfers occur. If facilities are renovated or replaced, movement will follow. If healthcare infrastructure is centralized or decentralized, movement will follow. If legal standards tighten or expand, movement will follow. The key question for policymakers is not whether transfers will continue. They will. The question is how to balance three goals at once: public safety, institutional security, and public accountability. Psychologists, legal scholars, and corrections professionals agree on one point: secrecy and silence carry consequences. They affect trust. They affect family stability. They affect how communities perceive the legitimacy of their justice system. At the same time, complete openness is unrealistic in a world where transport operations must remain secure. The challenge going forward is not simple. It requires careful policy, thoughtful communication, and recognition that behind every administrative form is a human life subject to the full authority of the state. The vans will still leave their gates, but the conversation about why and how openly is no longer silent. Psychological and system analysis. Final reflection. From a psychological perspective, Louisiana's silent death row transfers illustrate how environment, uncertainty, and control shape human behavior. Sudden movement in a highly restricted setting increases stress, heightens vigilance, and can intensify feelings of isolation. These reactions do not excuse crimes or change legal responsibility, but they explain how system design influences mental health outcomes. From a systems perspective, corrections departments operate under constant constraints. Limited budgets, aging buildings, legal mandates, staff shortages, and public scrutiny. Transfers become a multi-purpose tool, a way to respond to court orders, manage risk, address medical needs, and reclassify individuals. The consequences are layered. For inmates, disruption, uncertainty, and psychological strain. For families, distance, communication challenges, and emotional burden. For institutions, ongoing legal oversight and public accountability. Understanding these dynamics helps move the conversation beyond myth and toward informed citizenship. It allows the public to see transfers not as mysteries, but as decisions made within a complex network of law, policy, and logistics. The story of Louisiana's death row transfers is not defined by dramatic scenes or headlines. It is defined by quiet movement, structured secrecy, and the long shadow of policy decisions made far from public view. These transfers reveal how a justice system manages its most severe sentences and how that management affects real people on every side of the prison gate. By studying these silent moves, we gain clearer insight into the balance between security and transparency, and into the responsibilities governments carry when they hold power over life, death, and confinement. Public awareness does not threaten safety. In many cases, it strengthens systems by encouraging oversight, fairness, and careful decision-making. The questions raised by Louisiana's experience continue to matter today, not only for those on death row, but for anyone who believes that government power should be both strong and accountable. Thank you for watching and learning with us. If you found this documentary helpful and would like to see more fact-based, educational content on justice and history, feel free to like the video, subscribe to the channel, and share your thoughts in the comments.